Hi, I'm Monica Petrozelli, and welcome to Disability Advocacy Weekly, your weekly update on the issues affecting Americans with disabilities. Each week, we review the top national stories and local issues making headlines in the world of disability advocacy and provide resources that empower you to help make a difference. Our weekly video coverage in podcast format can be found on our website at www.disabilityadvocacyweekly.com. At this year's Democratic National Convention, former Senator Tom Harkin used his speech to focus on Americans with disabilities. Harkin discussed the fact that 26 years after the Americans with Disabilities Act, employers are still allowed to pay people with disabilities below the minimum wage. Passed in the 1990, the Americans with Disabilities Act, or ADA, is a comprehensive piece of legislation intended to protect the rights and interests of Americans with disabilities. It is also supposed to protect individuals with disabilities from discrimination in pay. However, according to the U.S. Labor Department, hundreds of thousands of Americans with disabilities have been paid reduced wages. This reduced wage is known as the sub-minimum wage and is a legal provision from an act dating back to the 1930s. The productivity-based wage allows employers to legally pay people with disabilities less than the minimum wage. Although President Obama issued an executive order in 2014 to set a minimum wage for federal workers, the order did not inhibit the use of sub-minimum wages for other employers in the U.S. The order's limited scope and qualification of sub-minimum pay has many disability advocates calling for more extensive reform. On the state level, Vermont, New Hampshire, and Maryland have already passed legislation that phases out the use of sub-minimum wage. The U.S. Department of Justice has issued new regulations to significantly expand the coverage of the Americans with Disabilities Act. Following earlier Supreme Court decisions that narrowed the application and definition of disability under the ADA, Congress enacted the amendments to broaden the definition. In a final rule published in the Federal Register, the agency is clarifying that a variety of conditions should be protected under the ADA, including cancer, diabetes, epilepsy, ADHD, and others. According to the Justice Department, the updated regulations will eliminate confusion about what the law calls for and how it should be applied. The new regulations will officially take effect October 11th. On Monday, the Boston-based Disability Law Center charged in a report that a Massachusetts school is guilty of neglect and abuse of its special needs students. The residential Chamberlain International School is one of 56 residential special education schools in the state. It serves students with conditions that are often too difficult for public schools to address. The report claims that the school has failed to prevent students from trying to harm themselves and from fleeing campus. The report concludes that the school is ill-equipped to handle the complex needs of all of its students. In a statement, Chamberlain called the report flawed and biased, citing unidentified individuals who have failed to report these incidents to responsible state officials. The statement also noted that the DLC alleges abuse and neglect, but did not release its report to any governmental organization responsible for the care of children. For more details on any of these trending stories, please visit our website, and please follow us on Twitter at Advocacy Weekly or on Facebook at DA Weekly for updates and our latest episodes. Thanks for joining us, America. For Disability Advocacy Weekly, I'm Monica Petrozelli.